Good morning. We are here today for oral argument in our case number CV22 0045 Sarber v. Paz. Each side has 20 minutes for your argument. The appellant can reserve time, but we don't keep it. You have to do that yourself. There should be a clock on that side for rebuttal. The proceedings are being audio and video recorded, and live streamed. So if you could introduce yourself and your client at the outset of your argument, that would be appreciated. We've read the briefs, discussed the case in conference, and are familiar with the arguments raised. So please keep that in mind when making your arguments. And with that, counsel, you may proceed.
Thank you, Your Honor. Good morning, and may it please the court. My name is Paul Stoller. I represent Kelly Sarber, who is in the courtroom with us today. Also with me are Ashley Crowell, Hannah Peterson, and Felice Wortman of my office. I appreciate the comments of the court at the outset, which I know are routine, that you've read the briefs, you've conferenced, you've met. I was a clerk here 27 years ago. Last month, and I know that things have changed a bit, but not that much. I regard appellate oral argument as my opportunity to answer your questions. I certainly have an argument to make, but I hope that we've made them well enough in the briefs that I don't want to be repetitive. So if you have questions, obviously I know you'll ask them as we go, but my belief is my primary tool here is to answer questions you may have to help if there are things that are unclear in our arguments or unclear in our briefs. I know you all know we're here on a summary judgment motion, an grant of summary judgment, which you all review de novo. And you all are familiar with the standards on summary judgment, so I'm not going to spend time going through that. What I want to talk about, at least to start, is the sole issue on the summary judgment motion as filed by the county in this case, was whether the agreement between the county and my client violated the open meeting law. And in particular, and I'm going to quote, Your Honor, Let
me ask you something,
sure.
Counsel. So let's say, first of all, I think your colleague raised a contract interpretation argument at some point in that summary judgment briefing, right?
I would agree at some point in the briefing, in the reply.
Okay. And if we decide that this contract, if we interpret the contract not to, let's say, include the solar energy project, do we have to reach the open meeting law arguments or the notice of claim arguments?
So I think that's what appears to be a straightforward question, but is a more difficult one, and here's why. I think on a full record, with full briefing, with ample opportunity to do the things that are necessary to reach a conclusion, if there were a contract interpretation question about whether or not the agreement between the parties encompassed the activities at issue, would that resolve the matter? Only if you found against us, right? If you interpret the contract to say that it's susceptible to the interpretation that both we and, by the way, the county administrator and one of the county supervisors have interpreted it and say that contract doesn't include those services and the activities with respect to renewable energy, the other issues don't matter. But I'm going to suggest to you that there's a couple of reasons why I think that under this procedural setting and this procedural posture, that's not appropriate. And it is that issue was raised for the first time in the reply. It had not been briefed. And I started with where I started on this, which is what was the sole issue in the summary judgment motion?
But isn't a summary judgment motion framed by the discovery and the complaint that precedes it and the disclosure statements that precede it?
Your Honor, I don't think I agree with that. I think a summary judgment motion is framed by the motion and what's the issue put up there. There are any number of issues. You don't get to start throwing them in hodgepodge at the end. The issue before the court and the record developed on that motion is as to the issue of open meeting.
Well, are you allowed to change your claim, hodgepodge, at the end? Meaning breach of A rather than B?
So I think the answer is it depends upon what are the elements of your claim and what's at issue. Let me jump ahead. So, and maybe I'm jumping ahead on your question to the issue that when I was reviewing, again, the briefing here and below, I felt a little bit like Alice in Wonderland going down the rabbit hole. How did we get here? And there is hit hard in their brief and in some of Judge Thomason's rulings, I believe, I'm not going to call it concept, an argument that we changed what we did, that we started with an oral agreement and we went to a written agreement. That, Your Honor, is not a change in claim. It's not a change in theory. It's not a change in anything of legal relevance. The difference between an oral contract and a written contract, legally, no difference in terms of elements of the claim, no difference in terms of elements of formation. There are issues where there is a difference between an oral contract and a written contract, for example, statute of frauds.
But isn't the difference of import in the context of litigation, whether or not either, both, or neither have open meeting law issues?
If I understand your question, I think the answer is yes. Is there an open meeting law issue with respect to either or both? The facts here, and again, it was almost like an alternative universe. The facts here are undisputed. There was a notice. There was an open meeting. There was authorization given at that open meeting. There was a contract drafted by counsel for the county.
For the 2012.
For the 2012. That contract was sent to my client, to Ms. Sarber, and despite what the county's brief said, that it was returned. In fact, Mr. Fields expressly testified. He believed it was returned to him and that it had been put in the files. So the question then is, I think if I'm understanding your question is
my question is not that, I mean, what, in the complaint.
Yes, sir.
And in your disclosure statements, did you, I mean, what contract was breached? I mean, that's sort of the letter A in the alphabet.
It's not, sorry, I apologize.
No, so it's a breach of contract claim. If you look at the complaint, is it talking about the 2012 or the 2013 contract? And I understand they were very similar, but that's not my point. My point is, you are the plaintiff, you framed the inquiry, the battlefield. And if you're changing the battlefield, then new weapons or new fronts might be required.
I think I understand your question better, Your Honor, and I apologize for the confusion. We never changed the battlefield. Our complaint alleges that Mr. Field and Ms. Sarber met starting in 2011. And that in 2011 and subsequently they discussed and ultimately came to an agreement that Ms. Sarber would perform a number of services for the county. One was to go renegotiate the landfill use contract. Second was to provide consulting services with respect to the landfill. Third was that she would provide services for economic development opportunities in the county.
Okay, let me see, I'll make it easier. Can we assume the 2012 agreement met the open meeting laws and then reach the language of the contract and then be done? If it doesn't include the solar energy project? So we're assuming 2012 meets the open meeting law. Then again, this is all about what the contract. Do you agree that we can just go right to that?
I don't agree, and we moved to strike those arguments because they were improperly raised in the reply in support of the motion for summary judgment. And that's my point, Your Honor. Let me keep in mind the way this case played out. The county filed multiple motions to dismiss based on the notice of claim statute. No discovery was permitted while that was going on. Once the second amended complaint was on file, they lost the motion to dismiss on that, and we were allowed to take discovery. They very quickly filed a motion for summary judgment on the open meeting law. Then we were allowed to take discovery on the open meeting law, and we did that.
And what was the contract at that point that was at issue?
The contract is the agreement that had to do with the provision of services for economic development services in the county that resulted in...
Right, the one from 2012 or 2013?
Yeah. So there are two agreements in 2013. They're spelled out expressly, by the way, in our complaint. Those relate specifically to the landfill. There's a landfill consulting fee agreement where, subsequent to the original agreement, Ms. Sarber said to the county, hey, I need to convert the consulting services on the landfill into a dollar contract and not a contingent fee contract.
Well, there was the September 2012 meeting of the Board of Supervisors.
Correct.
Right? And then you have a contract that you allege arises out of that. And so you're telling me that was signed in 2013?
No.
Okay, so I'm going to call it the 2012
There is a
agreement.
2012 contract that is signed, what we have called the 2012 consulting agreement in our brief. It is Exhibit H to our, I think, our controverting statement of facts.
Okay, so at that point, going back to the question, when summary judgment ensued and discovery ended, was your claim based on the 2012 agreement or the 2013 agreement?
The former.
Okay, the former. And where in the record, and if you can give me more than one place, I'll take them down here, exactly do you say the 2012 agreement is what we are suing on?
Are you asking me where in the complaint?
In the complaint
versus in our response?
Disclosure, anywhere in the record. Complaint, disclosure statements, questions that, I don't know if that'd be sufficient, deposition. Where do you frame the battlefield as the 2012 agreement before summary judgment begins?
We had not identified specifically the 2012 written agreement as the battlefield prior to filing of the motion. We had not taken discovery prior to filing of the motion. We had been doing nothing but motion to dismiss briefing. We had identified the existence of a contract between my client and the county that included economic development services, based on discussions going back all the way to 2011. We identified as distinct from that agreement the two agreements reached in 2013. We never relied on the 2013 landfill fee agreement nor on the 2013 landfill consulting agreement as basis for our claim. We consistently said there was an agreement between the parties as to economic development services that was not those two agreements, and you've said, Your Honor, you said breach of contract claim. This is not a breach of contract claim. We're here about the dispute.
Declaratory, right.
Right? The point of the lawsuit was we believe we have an agreement with the county with respect to the development of the renewable energy project. We believe that the terms of that contract, they owe us a commission of 10%. The county has disclaimed that obligation, and we're here for a declaration of our rights. And that complaint that we alleged, could it have been alleged better in hindsight? Probably, but it's not. But I would say it's of no moment. The question is, did we set out the elements in a notice pleading state that set up the claim for declaratory judgment?
On summary judgment? You're talking about motion to dismiss.
No.
The elements of a claim you can plead?
The pleading standard in this state is notice pleading.
Right.
Correct. And in our notice pleading, we said there was an agreement between the two sides. That agreement included the property, the development project at issue, and they're disclaiming it. And we want a declaration of rights.
Okay, but this is summary judgment.
That's correct. A summary judgment motion was filed based on evidence. Summary judgments based on evidence. Our pleadings evidence, they have some evidentiary value. They're not dispositive. So I'm going to go back to what, I don't want to conflate the pleading standard and summary judgment standard. On summary judgment, it's their burden. Their burden to come in and say there's no dispute of fact, on the issues in this case, and we're entitled to judgment.
Okay, so...
And let me back up just for a minute to be clear, Judge. I could have pled the following in my complaint. We had an agreement. It was about this property. It was for 10%. They've disclaimed it. I want a declaratory judgment. That meets the pleading standard. I don't have to do anything more than that. Our complaint was actually a bit more detailed than that in talking about that those 2013 agreements were not the agreement and got into detail about the dispute. But for them to come in and get summary judgment on a declaratory judgment claim about the existence of a contract and its terms has to be based on facts. Our claim is pled properly under the statutes.
Well, does it have to have, I mean, we have 4 minutes left, so 30 seconds. A contract, when we're interpreting, when the words of a contract are being interpreted, the court does it as a matter of law. Certainly if it's plain and ambiguous on its face, is that accurate?
The principles of contract interpretation are first to give effect first to give effect to the intent of the parties. That's rule number 1 of contract interpretation.
And for that, we look to the words?
For that, you first look to the words and determine whether it's reasonably susceptible to the interpretation as offered by one or both sides.
Well, that's the parole evidence you're jumping to.
That's all, but that is separate and apart from parole evidence. Is it susceptible to that?
We only consider parole evidence if it is susceptible. Otherwise, we don't consider parole evidence. That's parole evidence. And you're right, I was going to get to that. And then you offer evidence outside the 4 corners of the contract. And so we look to that, and I think the law is it has to be reasonably susceptible, based on that parole evidence and your argument to the interpretation you're urging. And then we can consider the parole evidence. If it's not, we have to exclude the parole evidence.
I agree with you if the parties disagree on the interpretation. That's the fundamental question here, is do the parties differ on the interpretation? And again, the evidence we've put is not my client, it's the testimony of their witnesses. Their witnesses have said consistently, this contract covered the services. And on top of that testimony by their witnesses and their actions consistently throughout the years of having her do these services with, now they're saying no contract whatsoever, by the way. They consistently referred back to this agreement, to third parties. They said this agreement covers her services. And I'll tell you, Your Honor, and I don't want to get by somehow concede that I think that there's not an interpretation of this contract that covers her services. There absolutely does. Section 3 says, let me read it. Section 3 specifically says, her entitlement to services for compensation for development and or other economic development transactions or activities other than the operating agreement, which was the landfill operating agreement. So other than the landfill operating agreement, occurring within or benefiting the county as a result of consultants' work hereunder. She got a fee.
And what, if you keep going there, there's a placeholder that says add fee language?
Yes.
Okay, is that material in any way to the enforceability of the contract?
The testimony, and this is, we're getting to the point.
As a matter of law.
Let me see, but you're getting to the point about I was making before, which is this is not a record on which you can make a contract interpretation because it's not developed. I can tell you, and I'm not sure if it's in the record.
If the contract's not developed, then...
But it is.
This is a legal question. If there's a placeholder that says add fee language, you're saying that's an enforceable contract under Arizona law?
I am, Your Honor.
Your point is that the briefing wasn't developed on that issue.
You're
That's
correct.
your point.
And I can tell you that Dan Field said that was to refer back to the language that was immediately above it, about 10%. And that this is the problem we face in this issue, is that if you reach to the contract interpretation issues, because it was raised in the manner in which it was raised for the first time, these issues are not developed so that there's a complete record out there in terms of how do you, your question is valid, Judge, how do you address that?
Did you move under Rule 56 for opportunity to conduct more discovery? They changed the subsection, I think, to D.
We moved to strike the argument, Your Honor.
So you didn't move for 56D relief, if that's the right subsection, which allows you to call a timeout on the summary judgment and go do all the discovery you want.
Your Honor, we had done that at the filing of the motion. That's what we did with the filing. When the motion got filed, we asked for the opportunity to go take discovery on the issues with respect to the open meeting law, because that was the issue raised in their motion. They said we didn't comply with the open meeting law. Not that we didn't comply, that they didn't comply. Evidence 100% in their hands, not ours. Their actions, their people, their documents. And by the way, our response laid that out, came back, said, no, they did comply. Here's the agenda, here's the meeting minutes, here's the contract, here's all the testimony by the supervisors, by the county administrator saying, we did this, this covered the work. They then shifted to a contract argument in their reply and said, oh, what, Judge, you can't interpret this contract to cover this. Well,
if you could sum up, counsel, your...
Well, I think I'm trying to at this point then, and I hope I've answered your questions, but our point all along has been, and was below and is here, is that this is not the record on which to decide the contract issue. If they want to move for summary judgment on the contract issue, then that's fine, but it needs to be at the front. You can't put it at the back and we go into a hearing and we said, Judge, this is improper, and you go ahead and interpret the contract without the full record developed on what's the contract, what are its terms, how do you interpret it?
Thank you.
All right, thank you, Your Honor.
Thank you. Counsel.
Good morning, Your Honors. May it please the Court. My name is Charles Workin. I represent the County of La Paz, and with me this morning is my associate, Madalena Savory.
Counsel, when was from your knowledge, when did the 2012 agreement make an appearance in the lawsuit? I'm just saying physically, I'm saying as the object of the declaratory judgment.
In the response to the motion for summary judgment. That was it. And I'll sort of reset.
Response, not the reply, the response?
The reply was mine.
Right.
It was brought forward in the response to the motion for summary judgment. The situation was this, Your Honor. The complaint alleged an oral agreement in 2013. Then it was amended to allege that the oral agreement was made in 2011. But we moved, well, actually, we moved for summary judgment before that amendment occurred, as I recall. But we moved for summary judgment that there was nothing in the agendas or minutes from 2013 forward that would authorize that alleged oral agreement to work on this project. So our motion was we're entitled to summary judgment for noncompliance with the open meeting law.
So the original theory was not the 2013 agreement, it was an oral agreement.
It was.
That wasn't the 2012.
It wasn't 2012. That wasn't mentioned at all.
It wasn't the 2013 either. It was just an oral agreement.
It was an oral agreement, which, you see, she was approached in 2011 to assist the county in getting bids for the renewal of the landfill operating agreement. And, they talked about pursuing that. There was no written agreement yet. It seems from the pleadings that there was only an oral agreement. And in 2012, they're getting the RFP ready, the request for proposals for the landfill operating agreement, to go out to bidders. And so they have this meeting in September of 2012 where Mr. Fields, the county administrator, asked for authority to enter into an agreement with her to work on the landfill. And you've seen the...
Why didn't you move for summary judgment then, initially, when it was based on this oral contract, and I guess I'm answering my own question, based upon the express terms of the contract, oral contract? Right, so your argument at some point becomes look at the words rather than meeting the administrative process of open meetings.
We didn't have the words.
Okay, because it was oral.
Yes, because the problem here is that 2012 agreement that gets sent to her in with only the signature of Mr. Fields on it in December never comes back to the county. We don't know that it has ever been signed. Instead, she proposes in February of 2013 a different agreement to work on a monthly fee basis instead of a percentage contingency basis, because she says, I can't afford to do that. And she gets paid to do this work then going forward under the 2013 consulting agreement. And then when she in 2017 is bothering the county to get a written agreement to pay her a commission on a different project, not the landfill, but on this solar farm located somewhere else.
So you're focusing on the 2013. Let's focus on it. Is she compensated under the express terms of the 2012 agreement?
That 2012 agreement calls for a percentage, and she has not been compensated under that agreement.
No, I'm saying for the solar energy project.
I understand, and the solar energy project isn't covered by the 2012 agreement.
Okay.
It's limited to the landfill. What was authorized, what was noticed to the public, was to approve a landfill consulting agreement with her for negotiating the operating agreement, consulting on landfill matters, and economic development opportunities. That's all under the umbrella or in the context of the landfill. Then what happens at the meeting is that authorization is given to enter into an agreement with her to work on the landfill RFP and the economic development of the contiguous land. It was limited to that.
Was there any agency arguments made based upon, so Fields retroactively says, I meant to do X or I was authorized in the lawsuit? Was there any either apparent or?
No.
Okay.
No, that would be a twist that this case is, which has taken a lot of twists. That's a twist that has not been taken. So when she sued, she's suing on an oral agreement. Her notice of claim specifically says, I have an oral agreement that was made in 2013. She later tries to back that up to 2011, but no matter. When we filed the motion for summary judgment, we supported it with all the agendas and minutes from 2013 going forward, which demonstrated that there was no approval for this alleged oral agreement. She then came in under Rule 56 and asked for time to conduct more discovery. They wanted to have all the county's emails. I said to Judge Thomason, they can get all the email they want, but it's not going to make any difference because it's what happened at the open meeting that matters. That's all. He said, nah, give them all the email. And we did, 58,000 pages. And you know what they found? Nothing. And so then they come back in their response, like a year and a half after I filed the motion, they come back with a response that changes their case from an oral agreement to a 2012 written agreement that, according to their reading, applies to this solar project on land that the county didn't own in 2012 and was being developed the idea was to develop it for a solar farm. That everything changed. And now here we are again in the reply brief. This case has changed yet again to arguing that, our complaint under the notice pleading standards was broad enough to cover a 2012 agreement. That was
which probably did meet the open meeting laws.
Yes, that contract did, but then we reach your question, Your Honor. What does that contract say, and what does it mean? And it is expressly limited to the landfill and the contiguous land, not to anything else. It doesn't apply to land 26 miles away that the county didn't even own at that time.
Are there any equitable theories raised in the complaint, or?
No. No, the complaint started out as one for breach of contract, unjust enrichment. Declaratory judgment wasn't even in the game at that point. And then through the course of my successive motions to dismiss, they whittled it down to just a declaratory judgment action, asking the court to declare that we have an agreement and the terms of the agreement are these.
So any claim of unjust enrichment is not in the case any longer?
I'm sorry, Your Honor.
Any claim of unjust enrichment is no longer in the...
It's no longer in the complaint. No, it is not. And of course, if you have an express contract, you can't sue for unjust enrichment anyway. But this express contract wasn't part of the notice of claim. It wasn't part of the complaint, the first amended complaint or the second amended complaint. It didn't surface until the response to the motion for summary judgment, at which point we replied to deal with that new claim theory, and we argued that that contract also doesn't, as you read it, to apply to the solar farm, doesn't meet the standards of the open meeting, the requirements of the open meeting law. The public had no notice that this was going to be used so expansively. The express minutes, which are supposed to be an accurate description of the legal action taken at the meeting, and Mr. Fields admits that they are accurate, they don't cover the project to which he wants to apply the contract. So our reply argued that it doesn't meet the open meeting law requirements, and it would be futile to allow her to amend her complaint to bring in the 2012 agreement expressly. And I believe that Judge Thomason, in effect, although he doesn't speak in terms of futility of amendment, I think he agreed with me, because he knocked down all of their arguments about the scope of this 2012 agreement, the meaning of it.
To that point, though, the Superior Court kind of went far beyond what the motion for summary judgment was asking in its analysis. The court tackled additional issues beyond the open meetings in its summary judgment ruling, correct?
Well, only because of the actions of the plaintiff, who files this response that tries to change the case, and then in response to my reply, moves to submit the declaration of Mr. Fields, who tries to pass off this notion that contiguous is code. It's a proxy for other land. So, what is the court to do? And there was no objection at any point during these proceedings to the court going down this road as that road was being
But you would agree the summary judgment motion was on open meetings. That was the challenge on the open meeting.
It was, as to an oral agreement. And then my argument became that this 2012 agreement, to the extent that it exceeds the authority granted in the open meeting, it also bars her claim.
So this court would have to address the open meetings issue.
Yes. But also, and I think it's a question you don't even have to get to, if you take her position that this contract arguably applies to that project, well, then look at the contract.
If we accept that the 2012 contract met the open meeting laws, we go right to contract interpretation.
Yes.
And there's no need to reach either the notice of claim or the open meeting laws.
I think that's correct.
So Judge Thomason didn't have to, he was very clear about what he believed the meaning to be, and if that's what he truly meant, he didn't have to tackle the open meeting. He could have just assumed it. that it satisfied it.
Yes. But I think where he came out is that this belatedly relied upon contract, A doesn't apply, or you can put A and B in either order you want, it doesn't apply to this project, and even if it did apply, it's not authorized, it's not valid under the open meeting law, because the supervisors at their meeting did not give Mr. Fields authority to enter into a contract that would apply to anything other than the landfill and its contiguous land.
Right, but if we assume that it met the open meeting laws.
If you assume. And I agree that it does meet the open meeting law to the extent that it was authorized, which is to do the RFP on the landfill and to work towards economic development on the contiguous land, which only means contiguous, not...
But I mean, we need not reach that issue. We need not do that analysis. If we find the contract didn't apply to the solar
Yes, Judge Howe.
project.
Yes. So, and then you don't need to reach the notice of claim issue as well that I present as a cross issue. And on that point, before I run out of time, what isn't addressed in the reply brief with regard to that cross issue is that the declaratory relief that they seek will lead to a claim. It will not lead to a judgment, which they argue, and they are correct in arguing, it will not lead directly to a judgment, but it will lead to a claim. And if they were to get a declaration that they have a contract on these terms, well then the county, when and if the revenues start to flow, the county is prima facie obligated to pay her. Now, there may be other elements of a contract claim that she has to prove, such as I performed. And there may be defenses. I can't imagine what they are, but theoretically, there could be some defense. But that doesn't mean that there isn't a claim. That doesn't mean that the declaration has not led us to a claim. And if it could lead to a claim, you have to serve a notice of claim. And she did not comply with the notice of claim statutes in a handful of ways. I want to comment too about so we can be accurate about the record. Mr. Fields did not testify that the contract he sent to Ms. Sarber in December was signed and returned. He said he wasn't sure if it was. And there is no evidence from her that it was signed and returned. She tried to assert that in her declaration, which was deemed a sham and given no weight, and this court cannot consider it. So, with that, unless there are other questions, I will sit down with 4 minutes to spare.
Okay.
Thank you, Your Honors.
Thank you both for your argument. We will take the issue under advisement and issue a decision in due course. And with that, we are adjourned.